And today we have our lawyer here, giving us some advice for the community properties, wills, and the trusts. That's the topic that we always want to know, but not very clear.
Yeah.
So after the presentations, if you have questions, okay, this is a great opportunity to ask. Okay, if you are not married, prepare for it. Okay, if you're married with kids, this is the class you want to listen. Okay, so then you sit down. You sit down here tight. Okay. Yeah. All right. Now we give the time to Terence. Thank you.
All right, guys. So I had to throw a disclaimer right after he said all that, but I want to put out there right away in the beginning that I'm a intellectual property patent attorney. I'm not an estate planning attorney. So, but I received a lot of requests recently from people who want to know more about this stuff. So I agreed to give a very general, high level overview. We can talk about some of the things in this kind of area of law. But if you want like an in-depth analysis of your situation and stuff like that, I highly recommend you go to an actual estate planning attorney instead of me. But for a general brief overview of some of how the law works, I can give you guys a general idea. Yeah, sorry.
Can I get a copy of this? I got one.
Oh yeah, sure. I can send
Thank you.
And we have recording always.
Okay. All right, so we're going to talk a little bit today about community property, wills, and trusts. So first of all, I want to start the talk with community property because it kind of flows a little bit better into the other two. So property, the division of property can be a little bit different across different states. In California, which is where most of us all are, is a community property state. What that means is that California splits any property that you own into community property or separate property. And the basic idea is that the acquisition of property by either person in the marriage is treated as a contribution to your marital community. And that includes both salary and non-financial things and less tangible things like taking care of the house, taking care of your spouse and cooking food, etc. And regardless of what people may think of, and regardless of your opinions on these different level of importance, all the contributions of each spouse to this marital community are presumed to be equal. So one of the main questions that you have to ask when it comes to community property versus separate property is, when was the asset acquired? So if you acquired something before or after the marital community was created or it ended, or before or after the community was created, that makes a difference. And then if it's before or after it was ended, obviously that makes a difference. So a marital community starts with a valid marriage and it ends with permanent separation, divorce, or death. Now, the valid marriage is also important because obviously, not everything is always, clean cut and, very clear. And there are occasions where for example, one party may believe that they're in a valid marriage, while the other party knows that they're not. Or maybe they believe they do, but they're actually not. So for example, if somebody is already married and then doesn't tell your new partner, and you now move to California, you haven't told them about your previous marriage, and now you guys are getting married, and the one spouse thinks that you guys are married and everything is valid. If they're under that impression, and if they in good faith believe that they are in a valid marriage, then community property principles will still apply to them. However, that ends as soon as that spouse realizes that they are not actually in a valid marriage. So if they originally believed that they were, and then they later find out that they're not, the community property principles only apply for the period of time where they believed they were in a valid marriage. So the marital community ends with permanent separation, divorce, or death. And in California, living separate and apart is no longer required to establish permanent separation. So that means you can technically still be living physically together and technically be permanently separated. And because what the law looks at now is only informed intent, which means that you have to intend to be permanently separated, and you have to tell the other person, you have to inform them that that is your intent. And then in addition, you have to have conduct that's consistent with your intent. So for example, if you're in a situation where maybe you're financially unable to move out, so you're forced to still live together, you can still establish permanent separation if you let them know, and that's your intent. And for example, you prepare your own food, you don't share food together, you don't drive each other to work, you don't, etc. There's a lot of this kind of thing that can come into play. And of course, we'll look at your conduct to determine whether or not it was clear that you demonstrated your intent. So there are a few things that are presumed to be community property, and hold on, there are a few things that are presumed to be community property and a few things that are presumed to be separate property. So property acquired during the marriage. If you're married and you acquire some sort of property together, whether that's an actual property as in a house, or if it's a car, a boat, it's a basketball, it's property that you acquire together during the marriage. It's presumed to be community property. It's presumed to belong to both of you equally. Income from community property assets, for example, if you buy an investment property and you rent it out, the income that you receive from that rent is considered community property. Labor, earnings, salary, etc. So if one person is a stay-at-home spouse, the other person is working and makes $400,000 a year. Still, all of that $400,000 a year salary that you make is considered community property and belongs to both spouses. And any property that's acquired with community property, so that $400,000 is coming in, the other spouse isn't bringing in any salary. But if you go out and you purchase another property using that money, then then whatever you purchase is still considered community property. Now, what are things that are presumed to be separate property? Property acquired before the marriage. So if you come into the marriage, you already own a certain property, you already own something, then it's presumed that that belongs only to you because you already had it before the marriage. If it's after divorce or after permanent separation, then it's generally presumed that something you acquired after that is separate property. By gift or inheritance, even during marriage. So that's a big one, where even during marriage, if you receive something by gift or inheritance that's intended only for you, then that will be presumed to be separate property and it only belongs to you. Additionally, any income from separate property. So say you own a piece of property or you inherit a piece of property. You either own it before the marriage or you inherit it during the marriage and you rent it out. That rental income belongs only to you. It's separate property. So you can contrast that with the example earlier for the income from a community property asset. So what about a couple who, as we know, California is a community property state. So what if you got married in another state, you have a lot of stuff going on there, and then you move to California? The way it works is that now that you're in California, what you have is something called quasi-community property, QCP. And the rule for quasi-community property is that if the property is acquired by a validly married couple while they're in another state, and if what they acquired would have been community property if they had been married and in a community property state like California, then it's quasi-community property and will be treated like community property. However, this kind of clause is only triggered upon divorce or the death of a spouse that holds title to the property. So it's just something that doesn't really come into play until there's some sort of split or the marital community ends.
Otherwise, don't marry.
Or your alternatives are prenuptial agreements. You can always contract to say that, these things are, even though, we're getting married in the future, like this subset of things will still be separate property when we both agree that this is our intent. If you both have that agreed upon intent, you can make agreements to say this. And it doesn't only have to be before marriage. It can be during marriage. You can come to an agreement and write something out, or even like during the divorce proceedings. If both parties can agree, then you can write it down and make a contractual agreement and take things that, once again, because these are presumed, it's not set in stone. So they're only presumed to be this, but you can agree with each other that something will not be considered one way or the other.
Something about the prenuptial agreement. Is there any like cases where someone signs a prenuptial agreement? It can be, I guess, like in the future they do get divorced, that they could throw that agreement out the window. Not like.
Yeah,
I've heard of cases where people sign prenups, but then when they divorce, it doesn't actually.
Yeah, the way a lot of these contracts work is that if both parties agree, if both parties to the contract agree, then they throw it out. Like they can just decide, what, we agreed this a long time ago, things have changed. We no longer feel that this is the way that things should be. And because, we're the ones who made the agreement, we can make a change. But once again, all parties have to come to an agreement.
I guess my question is like, how much can a prenup enforce in terms of divorce proceedings? So I know
I mean, these contracts are, for more in depth, I'll direct you to a contract attorney of some sort, or a family law attorney. But in general, contracts are generally presumed to be enforceable if, all the parties intend for there to be a contract and, sign it, intend to be bound by it. And yeah, and there was no bad faith arrangements. So if one person didn't agree to it only because they relied on, something told to them by the other party that was a lie or was fraudulent or something like that, assuming everything was done in good faith, you can generally presume that the contract is enforceable. That's separate property.
Also, so it could, that separate property, it could be the money.
Sorry, could you repeat that?
Could be just the money. You don't have to buy anything, right? If you get inheritance money.
Yeah.
Is it considered property?
Yeah. Everything that, like I said, earnings, salary, all of this stuff is all considered part of the property for the purpose of this. So if you inherit a piece of land, that's separate property. If you inherit $20,000, that's also your separate property.
What if you use that inherited money to buy a property?
You could.
But that property.
If you use, so that's what I was saying before, is that if you use separate property, so for example, let's say you inherit $100,000 and you go out and you buy a piece of property, a piece of real property, land, then that land, as long as it was purchased entirely with your separate property inheritance money, that land is separate property.
If it's not entire, if it's let's say 200,000 come from another.
Yeah, if you use community property funds to pay for it, then it gets messy. And then depending on how it goes, they may start splitting up the value and say a certain amount of this property counts as community property.
Then you use your 100,000 on your own money, and then you start to buy a property, but your spouse help you to manage this property. Value added become add another 0, and he count, the spouse count, the value added partially should get back to him.
Yeah, that's a good question.
Yes, they can. So yeah, so if you have a property that's entirely separate property, and then your partner starts like adding something and adding labor or service or something to that property, and it becomes and that's like coming from the marital community because her labor or his labor and his like work counts as a community property asset.
No wonder
So
my
that-
wife feels cheap.
Yeah, so yeah, so it won't necessarily always be the entire piece of property. There's a few different ways of calculating it that depend on the particular situation. There's community property has a couple of like mathematical formulas that are involved in the law that for things like that, where you can calculate, what percentage of your earnings from this or what percentage of this is community property and what is still separate property. But yes, you can convert a piece of completely separate property into partial community property based on your later actions and the contributions of your spouse.
I mean, Terence, we can go on this for hours and hours.
Yeah, I mean-
It's all the
Yeah.
questions, but I do have one very,
Yeah.
very, okay, if that one person has a business, for example, they have a company, the LLC, S corporations, whatever, right? But in the case that person has to divorce, then what happened to the company's profit? The spouse can claim for that profit that person earned in that company as well? Or how does that go usually?
Well, I mean, so once again, it's a complicated issue. It depends on, for example, where the money came from to start this company and to fund this company, and whether what your spouse contributed. Were they, did they like contribute to the management of the property and the growth of this company? Were they maybe only a salaried employee? If they were only a salaried employee, then you can make an argument that they've already received the reimbursement for their contribution. So it can be very complicated. It depends on the particular situation. But yeah, so it will depend on what type of contribution your spouse has given and how much, if at all, they've already been reimbursed.
So for general speaking, if that spouse has no whatsoever in that company, has no position, has, just like nothing. But when the time of divorce, can the spouse say that I want some interest, I will claim that the company's, the assets in the company.
Well,
Should
it depends on, like I was saying, it depends on what the source of the funds to start this company, grow this company came from. If you use community property funds to fund the company, then yeah, they have some sort of interest in it. But if you, for example, only use separate property, that money you had from before, or money that you inherited to fund it, and then it becomes a little trickier of an issue because it seems like the source of everything for this company is all separate property.
Yeah.
But the wages, the salary that you earned during the time would probably be considered community property. But interest in the actual business itself, that's a little more up in the air. It depends on the exact situation.
sometimes shares, companies share.
Yeah, shares like that. So yeah, it can be a very, very messy topic.
Yeah.
So yeah, we're doing a brief overview of 3 different topics right now, that each of them are all entire fields of law. So there's going to be a lot of stuff where my answer's going to be, it's real complicated and we don't have the time to get into it today. And I'm not qualified because I'm a patent attorney.
We're not a series.
I'm not a patent attorney.
Terence said it.
Yeah, please don't do that. This is just a very general overview.
Wait for the next topic.
But yeah, so categories that are presumed community property, presumed separate property, and QCP. So upon split, when the marital community ends, what happens? The community property and the QCP, the CP and the QCP are divided 50-50. So you've been bringing in $1 million a year, your partner's just been staying at home. Assuming no other contributing factors, that all of that is considered community property, and upon a split, it goes half and half either way. And it's important to note that it's 1/2 of the estate not one half of each asset. So for example, you own a house together. You don't each have half ownership in the house and want to split. If the value of the house is, taken in, and then the sum total of your estate is split 50-50. So you don't get to split the baby, so to say. You get to, well, if there's an actual baby, it's not but to use the metaphor, just the phrase. Yeah, you don't get one half of each individual item of each asset. You get half of the total estate. And tracing applies for rebutting presumptions. That's a little bit of what I was talking about earlier. Is that you have these presumptions of what's CP and what's SP. Now, what tracing is if something is presumed to be one way or the other, you can rebut that presumption via tracing, which is just saying, no, this is not community property because it came the only money that I used for this was separate property, and you have to be able to show that you received, you have some sum of separate property before the creation of this community property, and that the value that was input into this community property doesn't exceed what you've already spent from your separate property. You can trace it and say, this is when this happened, this is when that happened. All of this should be separate property. So if you can trace the source of funds and the source of things like that, then you can rebut the initial presumption.
Okay, so Terence, when we talk about this, divorce, properties, separations, we always think about how much we can get, right? What about the debt? If people owe the money, once they get divorced, what happened to that, the debt? That's the question.
So yeah, it'll depend on kind of the source of the debt. If it's a debt that was taken on, as a married couple and for the benefit of the marital community, and once again, marital community has that really broad term, then it's likely that it'll be split between the parties. So the debt can kind of be considered a piece of property as well. If it's something that you already had coming into the marriage, then it's sort of like separate property where it's only on you.
Like a student.
Yeah, for like student loans, for example.
So you carry your own student loan,
Not the spouse.
Yeah, and then there's some arguments that people can make for example, if you were in school, your partner was working and supporting you, and you took out student loans, and then you got a really fancy degree, and now you make a lot more money, and your spouse has nothing because they spent all that time working to support you. They can make an argument that some of that, like some of the earnings from that and the extra earning potential and stuff, there's some sort of CP involved there. Your actual diplomas, your actual degrees and stuff like that is always your own thing. Yeah, you can't split degrees, obviously. But yeah, so
you
for
take a
debts,
credit card to help your spouse who's a student, medical student, that's common actually.
Yeah.
I can think of so many. And divorce. So the credit card debt, can it be shared, split, or?
yeah, the credit card debt won't necessarily be like split up, but it might be taken into consideration during the rest of the split of the sum total of the assets, the entire estate. Because like I was saying, you can't have one half of an asset, so you can't share credit card debt. The credit card is only attached to you, but that number and the amount that is there will be taken into consideration as a contributing factor for the whole estate.
See, we get married is a dangerous thing.
Now I understand why people don't want to get married in this country. Yeah, it's so different, from a different culture. Yeah, because it's
So you
just,
change your mind, Yankee?
it's so different in different cultures, and also it changes with time. For my culture, it doesn't matter because my time, or even slightly before, it's my own male dominant, right? because most of the finances, everything is taken care of by the guy. And then women is usually, sometimes these days things are changing, but it's not really too much of a problem.
Yeah.
And the rules are more in favor of the husband.
Yeah.
So here it's different. That's why they're really worried about getting married here because, you know, what happens if there's something problematic. And it's also, okay, this is all good only when you have a lot of property, right? There are nothing, you know, you got married and then all that is left is only debt. So then what happens? Then, you know, you're talking about wealth splitting. And if it's only a debt splitting is what's happening. Like if somebody is getting married and then they spend all the money and a lot of credit card debt, nothing else for the property, then as the wife or the other spouse is going to take responsibility for ownership of that too.
So it's.
So I love you so much, so I share with your dad.
Yeah,
Because
and-
I'm talking about, you know, not the rich, you know,
Yeah.
the middle or even lower people.
Yeah,
I think
so-
if they was what they do, they have nothing to offer.
Yeah,
Except.
yeah, so I'm gonna say, once again, not my area of law, but general idea is that, if the debt was taken on for the benefit of the marital community, if these debts are coming from food and, you know, gas and things that are for the marital community, it's more likely that the courts will find some way to say, to like share the load of that cost. Maybe one person will now owe a debt to the other, etc. If these costs are, you know, all personal, like one person is constantly going out to the spa for themselves, or they're just doing a bunch of stuff on their own for themselves, then, you know, it's possible that the courts will take that into account and say, you know what, no, these debts weren't accrued for the benefit of the marital community. This is just your own thing.
So when they have kids, what happens? Like, is that a 50-50 or?
Costs for children are generally always presumed to be for the marital community. Yeah, taking care of kids is presumed to be, you know, the duty of both parties.
So much of the asset is like needed to hire a lawyer. The lawyer costs a lot too, right? But you only have like 100,000, I will hire a lawyer.
You just talk between you.
I mean, if you have $100,000, it's probably worth it to our attorney. And, yeah, I mean, different attorneys are gonna charge different rates. And, you know, there's also potential pro bono options, so like, which you don't have to pay for. And, you know, you can, depending on your financial situation, you know, you can look into like certain like legal clinics and stuff like that.
Oh, okay.
That may provide services for much reduced cost or free and stuff like that. So I'm gonna say in general, it's always good to have legal help if you're dealing with legal issues. It's better to have someone who's an expert in that particular area than to do it on your own. So we've talked about community property, California's community property state. So now we come to wills. And if you don't have a will upon death, then all the community property and QCP principles that we just talked about all apply. And the surviving spouse gets all of your QCP. So, like while you're alive, technically you each have a 50% interest in the sum total of the CP. But if you die without a will, then your entire half of the CP would go to your spouse. Now for separate property, it becomes a little bit different because it's not, the community property goes to your spouse. That's a little more, you know, cut and dry, a little more simple to understand. But for separate property, there's a little bit more distinctions, and in general, these are the distinctions: is that if you have no lineal descendants, parents, issues of parents, etc., then all of your separate property goes to your surviving spouse. If you have one of the above, if you have one person who's in one of those categories, then half of your separate property goes to your surviving spouse, and the other half goes to the other person. But if you have more than one lineal descendant, so it doesn't matter if you have 2 children or if you have 70 children, 33%, 1/3 your separate property goes to your surviving spouse, and the rest is split among however many lineal descendants you have.
What about previous marriage? The kids at the previous marriage, do they have the right to get the property or the assets?
Yeah, so not to the community property that you established with your spouse, but for your separate property possibly, yeah.
Possibly.
But all
Yeah,
this,
because your separate property belongs to just you, not you and the spouse, it belongs to you. So if you have surviving children, then yeah, they would be able to say that they have an interest in that.
but the will you can write anytime, right? Suppose, in a hypothetical situation, right? Somebody gets married again, but then the previous kids are there, right? For the previous wife. And then he knows the terms are not going to go well, right? So he knows this kind of knowledge he has. So in that case, before the divorce, he puts all the money, property, whatever worth, most of them for the kid who is really is attached with the first wife, right? So in that case, he has not much property left after the divorce, right? But so is there a period,
So-
somebody can plan it out well in such a way that is favorable for him, even though it's not the right thing to do. So is there any rule to prevent this?
So, yeah, so if you have, so in this example you're talking about, are you trying to transfer CP, like transfer things that were acquired during the marriage?
Yeah, whatever I think, it's an asset, like here,
So generally, you're gonna have like a good faith requirement. So if you do things in bad faith, then you're gonna be punished, and the spouse that you're trying to, defraud is gonna be rewarded. And they might be, so if you might end up giving up your entire right to any of the CP, your spouse has the right to all of it, and then you leave nothing behind to anyone. So yeah, it's generally, like if you're doing things in bad faith, you're like doing things for the purpose of trying to skirt around this, the law is generally gonna favor your spouse and the person
how do
trying
they
to
prove it?
fraudulent.
It's hard to prove that, say, it was all planned. We never thought we will break up. It suddenly happened. So, but this was pre-thought, this was a decision for my commitments for my previous marriage, I felt genuinely, so I did that.
Was it
And
written,
this happened later, so it's a proof.
was it written down?
There's not,
It has to be written down. It has to be, if you have this plan set up with your previous spouse, it has to be written down. Or else they're more likely to presume that you're trying to defraud your current spouse.
it's very complicated.
So the descent from the first marriage and the second marriage, they share equal right?
In general, yeah, if they're your children, then
Even
yeah,
the
they're kind of in the
first-
same category.
First marriage has been dissolved, but still children is children.
Yeah, they're still your children. You can't legally dissolve the fact that they're your children. Like, I mean, I guess you can, but for the purposes of this, like, unless there's disowning and stuff like that happening, then it's just, they're your children. It's presumed that they'll be treated in like the similar category.
So who enforces this? So I know it says like, if, like, let's say I have 3 kids, right? So the 66% gets split up between those 3 kids, 33% goes to the spouse.
Yeah.
But like, who would make sure that these kids are getting their money, the wife's getting their money?
So all wills have to go through probate court.
Well, this is
Or-
no will, right? So like, if there's no will, I die, it's supposed to get split up, 66-33. Who then enforces? Because there's a chance that, I guess, like, my wife, right, she gets this, like,
Yeah,
I don't know if
so-
she's actually giving it to the children or putting it in the correct, allotting
Yeah.
it correctly.
Yeah, so I'm not 100% sure, but I'm pretty sure it's still probate court. Because probate court is, the court that, after you die, that like handles your will and like handles the distribution of your property and stuff like that.
Okay.
So even if you don't have a will, I'm pretty sure probate court has still handles that. Could be wrong, but I'm pretty sure that's how it is.
Okay.
Yeah. So in California, there's 120-hour rule that applies to a couple of things, but in California, it only applies to the fact that an heir must survive the decedent by 100. Decedent is the person who died by 120 hours in order to take by intestacy. Intestacy means dying without a will. So if you die without a will, your heir has to live for at least another 120 hours after you before they have like the right to take whatever it is that they have a right to. And for simultaneous death of spouses, in general, it's 50% of the CP goes to the estate of each person. So if you're in a car crash and you and your spouse both died during a car crash, then the CP is just kind of split in half, and the value of the estate, 50%, goes to each person's estate. And in California, death is defined as an irreversible cessation of circulatory and respiratory or brain functions. So, the execution of a will. How do you kind of create this will and make it something that's enforceable? So the writing must be signed by the testator, which is the person who's making the will. The testator must be 18 years old, of sound mind, and have the intent to create a will. So if they're just, writing down for fun, oh, all my things go to my friend Bob, but they're not intending to create a will, then it's not going to be considered to be a will.
So what about the interest, the person's interest? Can I write a will that include the persons that not in the family?
Yeah.
Lovers.
Yeah.
Lovers, right? You write a,
Sure.
you're valid, give somebody to the lovers. Is that valid or?
Yeah, you can will for your things to be given to whoever you want. They don't have to be related to you.
Okay.
Yeah.
Well,
And
we
then-
heard about some will go to their dog.
Yeah.
Years old, the dog has died, right?
Oh, no, the testator must be 18 years, so the person making the will has to be 18 years.
Oh,
So if you, in order to write an enforceable will, you have to be 18.
oh, I see.
So you could write the will to the dog as well.
Yeah, and there are people who do that,
Oh.
and it kind of depends on the state and the courts.
But how the
and
dog
they
will claim
enforce
it if you are?
Probate court. Probate court will say that, you know what, like, this property, this house that you left to your dog now belongs to your dog, and ideally, you would have assigned someone who's gonna help your dog manage it. And if you didn't, then the court probably will. Because in my experience, dogs aren't the best property managers. But yeah, and then in California, California does not recognize oral wills. There are other states that potentially do. Now, for the execution of this will, you have to have two witness signatures. So you have to have two witnesses to this creation of this will, and they have to sign it as well. Now, your witnesses don't need to actually read the will, so they don't need to know what the will says and what is in there, but they have to know that it is a will. So they don't need to know the details, but they have to know that what they're witnessing is this creation of the will, and they're signing saying that they know it's a will, and they're here to witness it. There's no minimum age requirement to be a witness, but the court has to agree that, like if they're younger, the court has to agree that there's sufficient mental capacity and maturity to comprehend the value of the act. So even if you're, if the witness is your 14-year-old daughter, she's a minor, but she's in high school, she understands what's happening, she has the mental capacity and maturity to understand what's going on, so it's generally going to be accepted. But if you have your 2-year-old kind of scrawl their name across and you tell them, hey, you know what, this is a will, this is what's happening, they don't have the mental capacity to understand that, so that's not going to count. And ideally, the witnesses are going to be uninterested, which means that the witnesses are not being given anything in the will. If you have two uninterested witnesses, that's great. But if at least one of your witnesses is an interested party, then in California, there's a presumption of undue influence, which means there's a presumption that there might be something going on here. You might be like forcing this person to give you their things, and you're having an undue influence on them that is improper in order to receive things that you shouldn't. So there's a presumption in place that you can then later rebut through various evidence, things like that.
Are these required? Like, so let's say like me, I feel like I'm not feeling well, so I go into my computer and I write out a will, right? And I die, but no one else saw me write the will.
We'll get to that.
Okay.
Yeah, so this is for a proper will, the way that ideally should be done. And, it's logged, it's typed out, it's signed, everything. So what you're talking about is gonna be called a holographic will.
Okay.
So a holographic will cannot be typed. It has to be handwritten. So you can have, if you handwrite a will and you sign it, you can create a holographic will, which will be accepted as a proper and valid will. And for this, it doesn't need to be witnessed or dated, but it has to be clear that it was intended to be a will, presumably in the way that you write it and what you said. So obviously, this is an area that can create some conflicts and some debate, but in general, holographic wills are accepted, just can't be typed, has to be handwritten and signed.
But in the formal will, usually how much it costs to do this? And then how are these documents preserved? Because you have a bill, this is a piece of document, right? It's like like a lab notebook, right? It's an electronic way of securing this, right? Because you wrote a bill and then but then this document is kept somewhere, nobody can have access. Like how is it, even accessible? How is it, like set in stone? How you can make it that way?
So as far as costs go, I can honestly say that I have no idea how much it costs to acquire legal services for the right will. So for the wills that we talked about before, they're generally done with witnesses, probably an attorney. It'll be recorded somewhere. For these holographic wills, what ends up happening a lot of the time is they might have written it like onto a desk, like in a drawer or something. They like have this whole thing written out, and then when all of your assets and everything's been collected, somebody finds it. Someone's like, "Oh, they left a holographic will." That's generally how.
But you never know, right? It could be a friend, who can write exactly, maybe his handwriting. Oh, this is what he did. He gave all his property to you see. So how do you know? Like, how do you know this kind of forgery is happening in this handwritten?
Well, no, you don't need a witness for this.
Yeah, so it could be somebody who knows how to mimic the writing, because
Yeah.
these days it's all possible. People develop different skills.
Yeah, and that's why you have attorneys. That's why you go to court.
But this one, yeah, no, right? The hand holographic will is not possible. It should be possible.
Yeah, well, you go to court and you have to argue, say like, we don't think this is a valid will. We think it was forged by, so and so. And then what evidence can you present? Like what, knowledge do you have, or like what can you do to prove this is the case?
Don't write on that napkin.
So are they really preserved, people in one place, it isn't like, how does even the person who's living, you never know when you're going to die. So you really, okay, you made a bill and then it's somewhere there. How does even this person secures and then knows, okay, I have an attorney or something? Somebody should have this knowledge, right? This is kept in more than one places, or, is it usually, I don't know who is the one who's going to take a leave when the person dies. There's a lot of old people there, sometimes they made a bill, but then who is going to even go after, this will be.
Yeah, so a lot of times you might appoint an executor. If you appoint someone who's going to be in charge of taking care of your will and things after you died. But the courts can also appoint somebody to be in charge of this. Yeah. So those are wills. Now we're going to go into trusts. Now a trust is not necessarily an alternative to wills, but it's like sort of another vehicle. It's not an and, like one or the other kind of situation. But a trust is a legal vehicle where the grantor is the person creating the trust, gives a third party or another party, which is the trustee. The trustee has the right to hold title to and administer property, assets, etc., for the benefit of a beneficiary, some form of descendant or otherwise that you're trying to give the benefit of this trust to. And at least for me, when I think about trust, I usually think about, trust fund kids, people with a lot of money creating trust to like, for their children to just live off of. So in that vein, one of the trust options is the spendthrift trust. And in this sort of example, the beneficiary's power to transfer the interest of the child or whoever is the beneficiary of this trust, their ability to control the assets in this trust is fairly limited, and the trustee, which might be a person, it might be the grantor, it might be an institution, a bank or something, has the power to kind of control that and make sure that they're not just blowing all their money. And this type of trust, creditors usually cannot reach it unless the creditor is owed money for child or spousal support, basic necessities, or their tax lien holders, that type of thing. Then there's a lot of different types of trusts. I'm going to go over a few of them. So testamentary trust is something that's created in writing, in a will, or in a separate writing that is then incorporated by reference into a will. And then that trust will be valid so long as the will is valid. A charitable trust is one where you're not trying to leave your assets to a person, you're trying to leave it to a charity or for the general betterment of society. So the beneficiary has to be the community at large and not a specific person. It can be a specific charity or it can be the general intent of charity. So if the purpose of your trust, and every trust has a defined purpose, and if the purpose of your trust, let's say, is to donate to a charity that gives clothes to homeless people, let's just use that as an example, it has to be kind of defined whether your intent is to give your assets to this particular charity, in which case, if the charity is discovered to be illegal or fraudulent or some other issue, then whatever assets you're leaving to them, if you were wanting to give to this specific charity, becomes just kind of the rest of your estate, and then it's split up according to the regular rules. But if you chose this charity, but the purpose of your trust that you put down wasn't to give it necessarily to this charity, it was to give to the betterment of the community at large and give clothes to homeless people, then if this particular charity is found to be illegal, bad, fraudulent, etc., the courts will find another charity that provides a similar type of societal benefit and apply the charity to that. So the courts will just choose a new charity for you. Discretionary trust is another common type of trust, and that's where the trustee, which once again is that middle party, the trustee has complete discretion about whether to and how to apply payments to the beneficiaries. And this is a commonly used method of trust because the creditors who are trying to get at your money have the same rights as the beneficiary. So the trustee can exercise a little more discretion and try to keep the money away from them. Excuse me. So that's one reason where that's a commonly chosen trust. Obviously, a lot of finer details that go into that. Mandatory trust is sort of the opposite of the discretionary trust, where the trustee has no discretion whatsoever. They don't have any power to decide how the assets are distributed because the trust itself governs how it's distributed. It's all written down already. This has to happen at this time. This has to happen if this happens, etc. The trustee is only in charge of kind of making sure that that happens and to be the person who's in charge of it. They themselves do not have any discretion. And you also have support trusts where the trustee pays as necessary to support a beneficiary. So you set up a trust that in order to support another person, and then when they need money, you can dole out payments. And this one is also another one that creditors generally can't have a lot more trouble reaching unless they're providing a necessity to the beneficiary. So trust can be, one common way that a trust is done is through a living trust or an inter vivos trust. And this means that the trust is created while the person is still alive, and the settlor, which is the creator of the trust, a lot of times in this case will name themselves as the trustee until their death. So they create this trust, and then they set themselves as the person who has the discretion to kind of control the assets in this second capacity. So in a lot of these, they can change, while they're still alive, they can change who the successor trustee is, which means after they die, who is going to become the trustee, who's going to be in charge of this. They can change the beneficiaries, they can change who has access to assets, they can change the assets in the trust. And because of this flexibility, in general, this type of trust is not going to be as well protected from creditors and federal state taxation. So that's kind of the balancing act. If you have way more control over what's happening here, you have free access to it, it's not as well protected. And this is primarily used for capacity planning. If you think, in case of in the event of future capacity, and to try to avoid probate court at the grantor's death. A lot of trusts are done for that purpose, to try to skip and avoid probate court. And a trust can be revocable or it can be irrevocable. So one that's revocable, the settlor must have expressly reserved the right to modify or terminate the trust in order to have this ability. So like the living trust that we just talked about, has to be written in there that this is a revocable trust, that the settlor maintains the ability to go in and change things around. If it's irrevocable, then you can only change the details inside the trust and modify it if all the beneficiaries involved consent to it, and if the change will not interfere with the primary purpose of the trust. So for example, if the primary purpose of your trust is to give to a certain charity, you can't suddenly just change it to give all the money to my daughter, Jane. It has to still align with the purpose of the trust. So if it's a charitable trust, the beneficiary has to be community at large, can't be a specific person. So that's it. It's a very brief overview. Thank you guys for listening. And if you have deeper questions and personal questions and details that you want analysis for, please be sure to contact an estate planning attorney for more in-depth questions.
If you find a tenant lawyer, it's typical or something, we open the door for you.
Yeah, switch from patent law to estate planning. I don't know. I like patents and intellectual property a lot better.
Right, thank you.
Thank you.
Don't people usually do trust because it helps avoid the estate tax after death?
Yeah, it's a way to kind of avoid a lot of tax.
So
Thank you.
But typically we need to have just a good amount of.
I don't know.